Hi. So, two big notes about today's material, one practical and one about where our discussion's focus will be. Then I'm going to lecture about publication and other formalities. First, formalities are important and you do need to know about them. You did well on the LSAT, that means you can do well on formalities. Second, I lived through the duration wars and I have some scars from the process. The Eldred majority and the dissent are both really good opinions with some small exceptions. And so I will probably only be pursuing lines of argument that interest you rather than going into detail about all parts of the case. The purpose of formalities is generally to limit copyright protection to the authors who really want it. The default rule of US law, until we acceded to the Berne Convention, was that works went into the public domain unless the authors took special steps to prevent that, particularly providing notice and then renewal after the first term. Gradually, Congress began to take the position that copyright protection should be the default, not public domain status, which explains the progressive collapse of most of the formalities. So here are the formalities: publication, notice, registration, and deposit. Here are also some important dates. The effective date of the 1976 Copyright Act, so that will affect duration a lot. And then March 1st, 1989 is the effective date of the Berne Convention Implementation Act, which has implications for notice as well as restoration. So we're going to start with the pre-76 Act formalities. Publication was a key but undefined concept. In order to avoid the harsh results of finding that there had been a publication without notice, which would end the common law copyright and put a work into the public domain, the courts developed several concepts to make it harder for creators to lose their rights. Only a general publication without notice would forfeit copyright. A limited publication without notice would be okay. For a single work of art which was on public display, attempts to control access and prohibit photography would also be interpreted as avoiding a general publication. Restrictions on copying could even be implied from context. A key rule developed: public performance was not publication. So many things that were widely disseminated were still unpublished under the pre-76 Act rules. In the estate of Martin Luther King case, the I Have a Dream speech was found not to have been a general publication. There are two important rationales. First, broadcast isn't publication, no matter how widespread. So that's a pretty clear rule. Second, giving copies of the speech to reporters was a limited publication because reporters were a more limited group than the general public. The court relied on precedents saying that distribution to the news media for the purpose of reporting on a newsworthy event was only a limited publication, even though distribution to the general public directly would have been a general publication, unsurprisingly. Here's the difference and why Estate of King represents a step forward in terms of relaxing formalities. In prior cases, the distribution to the news media had been for purposes of what was called fair comment. That is, the distribution allowed the press to quote parts of a speech, as opposed to what they did with I Have a Dream, which was distribute the speech so the press could reprint the entire thing and make it available in its entirety to the general public in print copies of newspapers. In the King case, the papers did reprint the whole thing, a fact that you could not have known from reading the opinion. The court's reasoning in the King case is a stretch at best. Giving copies to people that you know are going to reproduce them in their entirety for the general public pretty much defines general publication. And you can see this in the subsequent definition of publication used in the 76 Act. But the court is clearly interested in giving the estate the economic benefit of owning the copyright in the speech. And King did take steps to assert a copyright interest soon after he gave the speech. He quickly formed the intent to assert a copyright interest. Just know that had he litigated the issue at the time, the courts would have thought that it was too late. In the actual litigation, the court is operating in the post-1976 mindset that copyright is the default, rather than the pre-76 mindset that copyright is something that has to be affirmatively preserved. The case settled, so there's no definitive ruling on whether the King's speech is in the public domain, but the estate continues to assert rights. The empirical evidence, based on a study by Deborah Gerhardt, suggests that when the issue of whether there was a general publication is litigated, obviously a biased subset, almost 2/3 of litigated cases find that publication occurred. Music and film are the exceptions. They're only found to have been published a little bit over half the time. When cases involved the sale of authorized copies, courts found general publication virtually 80% of the time. In practice, distributing copies by retail, lease, or lending instead of by sale is correlated with a greater likelihood that publication won't be found, despite the 76 Act statutory text. Courts also seem to treat public performance and public display differently. Public performance isn't likely to support a finding of publication, but public display is very likely to do so. So that has a differential effect on things that are performed versus things that are displayed, like paintings and sculptures. This is possibly because public display offers an opportunity for people to make their own copies pretty easily in ways that public performance in the past did not. As a practical result, there may be discrimination in favor of creators of audiovisual and musical works. Publication is less likely to be found when works are deposited in a government archive, such as a local zoning commission files, maybe on the rationale that this wasn't truly a voluntary surrender, even if it's easy for people to make copies from the submissions. Publication is more likely to be found when a work is deposited in a public archive, such as a museum or library, and when the work is given to the archive by the copyright owner. The definition of copies in the Act says that the original or first fixed version is, for copyright purposes, a copy of a work, but courts don't follow that principle when it comes to publication. If the only copy of a work is sold to someone else, that substantially decreases the likelihood that the court will find that the work is published. You can also see from the King case that the publication rule created a bunch of problems with new technologies. The copyright bargain had been that you get federal protection for a limited time, but publication ensured that there was public access and that the protection eventually ended. If King hadn't given out copies of the text to reporters, it is quite clear that the broadcast to millions would not have been publication. Because common law copyright protected unpublished works, creators could claim perpetual protection for works that were distributed in new ways. There were thus problems of underprotection and overprotection that contributed to Congress's abolition of publication as the key moment for when copyright protection attached. Nonetheless, publication still remains important for many things. We'll talk about them in class. Now a bit about notice. Why do we have a notice requirement anyway? There are common justifications. First, putting notice on a work showed an interest in acquiring copyright rights, and conversely, lack of notice was a signal to the public that copying was legitimate. Second, it gave people the ability to contact the copyright owner if they wanted a license. Third, it allowed people to calculate the duration of copyright protection. The notice requirements tracked those reasons, generally requiring the copyright symbol, a date, and the owner's name. Date is now a strange requirement since the date of publication now doesn't give you very much information about copyright duration for things that aren't works for hire. And it also created some conceptual problems and practical problems. For example, for freelancers, if a freelancer licensed a news article to a newspaper, the newspaper's notice could or could not be enough to preserve the freelancer's own copyright in their individual contribution. So eventually, courts decided that the newspaper's notice was enough to preserve the copyright. But again, that means that the name is not necessarily the name of the copyright owner. The elimination of notice, as well as registration as requirements, flips the default rule. You have to assume that all works are copyrighted and that you proceed at your own peril when you decide to copy a work. You can't even check registrations with the Copyright Office to be sure. Some works are registered, but not all. So a bit about registration. So initially you had to register at least in order to file for the renewal term, which was an incentive to do so for works of continuing value. Registration became optional in the 76 Act. However, US works must be registered in order to sue in federal court for infringement. There's a partial exception now with copyright small claims, but even then, having a registration before you file in the small claims court gives you access to better remedies, bigger damages. Timely registration also has evidentiary benefits. Timely for purposes of validity means within 5 years of the first publication. Timely registration is also required, as I mentioned, for certain remedies, but there timely registration actually means a different thing. It means before the infringement started, because of the different reasons that we hand out remedies versus that we might presume the validity of the registration certificate. All the evidentiary benefits are rebuttable presumptions. So it's presumptive proof of dates of creation and publication, of the identity of the copyright owner, and the validity of the copyright. These can all be rebutted. The Copyright Office issues registration certificates, but it only does a minimal inspection for compliance. It doesn't investigate or examine the way the PTO does for patents or trademarks. So it's very easy to get a registration, and a copyright registration will not have the evidentiary force of either a patent or a trademark registration. In addition, so the time of registration will control the availability of statutory damages in judicial proceedings, as well as the availability of stepped up statutory damages in small claims proceedings. And this is true even for non-US works. Likewise, attorney's fees are only available for timely registered works for US and non-US works. This is allowable under international law because TRIPS and the Berne Convention only require that we make actual damages available. Statutory damages and attorney's fees are optional, so they can be made subject to formalities. This has led some people to question, could we restore formalities without violating the Berne Convention? Yes, we could do it for some things. We could do it for domestic authors. We could do it in the last 20 years of the copyright term, since life plus 50 is the only requirement of Berne. So we could do anything for everyone in the last 20 years of the term, including requiring notice or re-registration, as some have proposed. We could limit remedies. Statutory damages are not required by Berne. So we could require notice as well as registration before we made statutory damages available. Our various bilateral trade agreements might, in theory, constrain our behavior there, though. Final related procedure I want to talk about is pre-registration. So this provision basically is not used very much, but the copyright owners were worried about like leaked movies and so on. And so Congress made this available to make statutory damages available. Turns out, doesn't matter, not much used, but it is in there. Finally, I want to talk about restoration. So these are provisions for works that lost protection due to failure to comply with US formalities like notice or the renewal requirement, or because they were pre-1972 sound recordings. Restoration does not cover any works that were unprotected in the United States for other reasons. For example, failure to meet US originality requirements. So the work still has to be in copyright in the home country at the time of restoration, but after that, it will have its duration calculated according to US rules, which often produce longer copyright terms than foreign rules. Foreign owners needed to take affirmative steps to recapture their works. They needed to file with the Copyright Office within 24 months of restoration. That started in 1996 and is obviously over now for all current Berne members. Or in the alternative, they can serve a notice of intent to enforce the restored copyright directly on someone who's exploiting the work, AKA a reliance party. And we will talk a bit about restoration in class. I will see you then.